They mention upon notice, my lord, one application in connection with the mandamus appeal, my lord, group 6 appeal. But I'm paying for updation. It is appearing in item number 90. Next week, my lord, if it is possible. Ground is this, my lord. He was terminated from service from the West Bengal State Electricity Distribution Company. On certain allegations, my lord, criminal proceeding also initiated. That was not, he was discharged honorably. On the basis of that, not the honorable single bench has not set aside the termination, but in the meantime, he has terminated. The back wages have not been granted. Appeal is not regarding back wages.
Only that.
Only for
Then there is no urgency. You wait.
He didn't get any money, my lord. He's starving basically. He didn't get any
Back wages are only involved. Let us see.
he's starving, my lord, without any money.
He'll get his pension. Why he'll stop?
There's no pension. That is the difficulty, my lord. He will only get.
That is not the issue before us. The issue is whether he'll get back wages or not. There is no urgency. That can wait. Yes.
Lordship may be permitted to mention a matter for correction in the last order.
Which order?
Lordship, in 23rd February 2026 passed an order.
What is the correction you want? Let us see.
Added respondent my lord instead of respondent number 145 came.
This number is incorrect.
It will be added respondent.
So is this number correct or incorrect?
Number is correct.
Then why? What is the problem with it? My lord, maybe identifiable, then there is no. Unless they are not identifiable.
Lordship, the difficulty here is that the direction is on the respondent number 1. And, my lord, the respondent number 1, my lord, is being shown to be represented by the learned advocate for the private respondent. That is the difficulty. The respondent number 1 is the state. My lord, so, my lord, the respondent number 1, my lord, needs to be omitted.
So who is representing the respondent number 1?
The state is represented, my lord, it's showing there in the order.
Then what is wrong that we
Lord,
don't
the
understand?
respondent number 1, my lord, will be, my lord, Mr. Kousheorai for respondent number 1 is written there. So 1 may be omitted. Because respondent number 1 is actually the state. That is the difficulty.
So 1 has to be omitted.
My lord, he's actually the added respondent. Instead of that, it's written respondent number 1, 4, and 5. That is,
You are appearing for?
I'm for the petitioner.
Let us see.
You will find, my lord, at the last, my lord, recording is it for the state.
Yes.
And, my lord, but the first one, my lord, it's written respondent
So
number
1 should be along with this set of lawyers.
But 1, 4, and 5, it's actually the added respondents.
Sir, 1 you are saying is state and 1 you are saying is added respondent. We don't know what you are saying.
1 is the state.
Then why you are saying it is an added respondent?
My lord, 1, 4, and 5, actually, when the petition for added respondent was being filed, it was recorded while Lordship was allowing the petition for addition of parties. It was written added respondent number 1, 4, and 5. So that is
So
why,
1 there is a repetition of number 1.
my lord.
There are 2 number 1s.
In the application for addition of party, there was 1, 4, and 5. And when the final order has been decided, my lord, it has been the same thing has been, my lord, written here. So that is the difficulty.
Listed, we'll see. We don't know.
My
We
lord,
can't understand what you are saying.
let it appear under to be mentioned, Lordship.
Yes, to be mentioned.
May be permitted to mention one thing, my lord. This is also correction of judgment passed on 18th of March 2026 in Can 1 of 2026, where in paragraph number 5, it's a tiny correction, my lord. And the respondent number 3 being the district inspector of schools, and in the bracket it is AC. It would be PE, my lord, primary education. This is only to this extent of correction.
All right.
May I be permitted to mention for this appeal for inclusion?
Give the inclusion you need not mention. Just hand over the slip. It will come.
One. Item number 1, when I'm appearing for the respondent, my lord.
Yes.
My lord, I'm appearing for the appellant. I led by Mr. Victor Chatterjee. I'm appearing for the appellant, my lord. I led by Mr. Victor Chatterjee. I'm praying for 1 week time, my lord.
Why, sir? Why?
Some
No, sorry. The third time.
my lord, may consider it as the last chance, my lord.
No, you proceed. He will come. What is the issue? Let us.
My lord, Mr. Somojuna is leading the matter, but
What
Mr.
is the issue?
Jumdar is not.
What is the issue? Come to the issue. Let us see what is the issue.
Well, the impugned order is at page 322 of the volume 2. 322 of the volume 2, madam.
Yes. What is wrong with the order? Let us see. Yes. Where is the inquiry report? Where is the inquiry report?
This is a case wherein he was the accountant officer.
Where is the inquiry report? We asked you.
Yes, 231. 158. One 60 it starts from.
Charge memo. So there was no witness. There was no witness.
Yes,
Was there any witness?
Lordship will, in your Lordship's, that page 203, my lord, entire thing has been laid down, my lord. So Lordship
Come to page 41.
the inquiry report, my lord, all the meals were visited.
Come to page 41.
41.
Now, these documents were required to be proved. By whom? This is the charge memo. You said at 31, rightly you said. It starts from page 32.
Yes, madam.
It contains the articles of charges. Annexure 1. Annexure 2 is the statement of imputations of misconduct. Annexure 3 is supposed to be the list of evidence and witnesses.
Yes.
So evidence we see there are 13 documents which are to be proved in the inquiry on a preponderance of probability, but by whom? Who are those witnesses? There's nothing about that in the charge memo. So how did you propose to prove these documents? And who has been examined in the inquiry? Not a single witness.
Well,
So based on documents, 12 documents, and without any individual supporting any of the documents, is it possible for an inquiry officer to conclude that the documents lead to sustenance of the charges alleged in the charge memo? Any supplementary has been issued regarding any evidence, any witness?
may I pray for your lordship one thing, madam?
Huh?
Give me 2 days of time, my lord. I'll come back, madam. Because, my lord, to be very honest before your lordship, my lord, but I was also, my lord, going through the documents, my lord. Your lordship, my lord, if you give me 2 days of time, my lord, I'll come with the entire clarification, my lord. Give me 2 days of time. Only 2 days of time. No. Number 2. My lord, I am for the appeal. Well, as per your lordship's last order dated 6th March 2026, may I be permitted to file my supplementary affidavit of service?
Served. Now it is served.
It has been served. The last page, if your lordships kindly come, there the endorsement is there. The first item. This is issued by the Sub Post Office, Haryana District, Hoshiarpur.
Varinder Singh.
Yes. He is the writ petitioner respondent.
When was it served? What is the 13-1? First column perhaps on the left side.
19th January.
19 or 30? Very good.
13th is the booking date, delivered on 19th.
Served in January itself.
My lord.
And what's happening in the criminal trial?
It's going on. He is appearing there. Next date is not known till now, but last date was 30th. 30th January, the last date where he appeared.
What was the order passed by the single judge?
My lord, what has happened is that he was prosecuted under the Prevention of Corruption Act. Now we suspended him under the Rule 40A of the Border Security Force rules. He challenged that suspension. He was granted subsistence allowance. He challenged that suspension, and the honorable single judge ultimately came to a finding that the suspension was invalid, and we have to pay him entire back wages from the date of the initial suspension. He, in the meantime, is superannuated. That is the subject matter of challenge.
That's the only thing. Proceeding was not conducted.
No. That was mainly passed on the ground, subject to your lordship's correction, that we have not initiated a disciplinary proceeding against him. A criminal trial is going on.
There is no provision for suspension pending a trial.
No, what the honorable single judge has come.
I'm asking you, what is your case?
Our case is that we cannot prosecute him when civilians are also involved. Our disciplinary proceeding, which we call it a GSFC, General Security Force Court, for that Rule 42 I will place before your lordship. For that GSFC is applicable only in respect of the members of the force.
But that's not the issue. As you said, we don't remember and we are not looking into that. As you said, if it is an issue as to whether he could have been placed under suspension without there being any proceeding.
Yes.
So whether you can proceed against him or not, that's not the issue. Admittedly, you cannot proceed him. So therefore, how can you put him under suspension?
Because when a FIR is drawn against somebody,
A member of the force.
member of the force, then Rule 40A specifically empowers the authority to keep him under suspension. May I
And
place it? May I place it?
that you have placed before the Honorable Single Judge.
Yes, yes.
Let us see the order.
One 128 of the stay petition.
So if you have yourself revoked the suspension,
Yes.
then how can he made to suffer for the consequences of that suspension for that period?
My lord, rule.
See, if it would have been a different thing, if ultimately during the currency of suspension, he was held or convicted in the trial or in some proceeding, then of course, if convicted in the trial, he would get nothing. If in GSFC something had happened, then you would have the option to decide how to deal with the period of suspension. But when you yourself have revoked the suspension, then how can he be visited with any consequences of that period of suspension?
But revocation of suspension after 6 years does not ipso facto validate the period of suspension in respect of an offense committed. That is not the rule. The rule says is that whenever a trial is pending against a member of the force, he has to be suspended. Now, whether will be continuated to in suspension or not, that
Then
depends.
if the rule says he has to continue, then why did you revoke?
He was going to be superannuated, that's why.
So what?
Because there was, my lord, may I once place rule
Let
40?
us see. So it's all an issue of the rule.
Yes.
Whether you have the discretion to do this or not. You are relying on 40.
40A. May I read it one?
So the suspension was confirmed by the central government.
Yes, yes. Every order of suspension that we have annexed, there is a footnote that it is with the approval of the Ministry of Home Affairs.
So this procedure in 4, 5 all has been followed.
Yes, yes.
There is a monthly review and monthly
Yes.
report.
Yes, yes, everything.
But then the officer competent to take a decision and vested with the discretion to continue the suspension decided that it was a fit case for revoking it. Now, therefore, now 40A is over. Now it's not a case of 40A. So what is the consequence of revocation of suspension? Can the consequences of deprivation continue after a revocation? That is the only thing.
That is act is silent. But my respectful submission before my lords is that the revocation does not automatically validate the suspension period.
Is there any provision under which a revocation can be done?
Because where the period for which he was under suspension, for that period he was granted subsistence allowance as prescribed under the fundamental rules. So he cannot agitate that he is again entitled to get the full allowance, full salary, full benefits for that same period for which he was granted subsistence allowance. May I place the FR fundamental rules once?
No, that's not relevant. That is not relevant in our view, prima facie view. That may not be relevant. If what you are saying is accepted, then the suspension itself becomes penal. That means you can penalize someone by keeping him under suspension for 6 months. He is deprived of half pay, no charge memo, no nothing. Finished. How can that be accepted?
Because
The
that is
suspension period is always subject to outcome of the proceeding. And if no proceeding, then the suspension itself cannot become a penal.
we cannot proceed under
You
this
know
act.
that.
Under this act.
You know that.
But at the same time, Rule 40A says when this
How that is relevant to a period post revocation of suspension? That's not relevant.
no, I'm
The
saying
admitted facts are suspension with effect from which date?
well, I'm telling you. Paragraph 6 of the code. Page 6, effective from 9th September 2013 to
And what is the date of revocation?
22nd February 2019.
19. My,
2019.
about 5.5 years. No,
But it
6,
depends, my lord.
5.5 or 6 years. 5.5 years. So 5.5 years, that means you are depriving him of his salary for about 2 years
We are
without any punishment.
no the punishment, the procedure is going on before the criminal
So
tribunal.
he will suffer if he suffers. If he doesn't, very good.
We cannot proceed. Kindly see Rule
That's not
42.
the issue. That's not the issue. We don't know, and it is hardly matters whether you can or you cannot. You suspended, you revoked. As a consequence, can he be deprived? That is the only issue. How do you sustain the deprivation without any finding of guilt? That's all.
My lord, my respectful submission is Rule 40A, Subrule 3, Subrule 3 and Subrule 4. Subrule 3 says an order of suspension made or deemed to have been made under this rule shall continue to remain in force until it is modified or revoked by the authority competent to do so. And subsection 4 says an order of suspension made or deemed to have been made under this rule may at any time be modified or revoked by the authority which made the order or by any authority to which that authority is subordinate. So it
That
is
is
the
over. 40A is long over. It
so
was
the
over.
revocation power is also
40A
under,
was over in February 19.
so the revocation power is under also 40A.
40A is over in February 19, sir. Now,
Revo-
after February 19, what is to happen? That is the issue. Nothing regarding 40A is an issue. 48 doesn't deal with the situation post revocation. It only deals with the discretion, power, and procedure of the competent authority to suspend, continue the suspension. That's all. That stage is over.
Now the issue before
Now the issue is post 40A.
the-
That after revocation, what is to happen?
now, may
On
I-
that, you admitted that the act is silent. There is no provision. So therefore, in absence of any provision,
No,
will it be within the competent authority's jurisdiction to penalize a person?
penalization is for the period of suspension,
Maybe for 2 days,
But not-
forget about.
but not after that, because he superannuated on 30th March, 30th of April 2019, after 2 months.
Whatever be the period, how do you sustain it? That is the issue. It may be prior to, subsequent to, whatever. Under which provision you are vested with such an arbitrary discretion to deprive a person of the remaining balance of the salary without any guilt being established or any finding of any charges being proved in any proceeding or criminal trial. That's the only issue. How do you
That
sustain?
is there in Rule 40A, Sub-Rule Clause 3.
48 does not deal with anything of that kind,
There are
sir.
case against him in respect of any civil offences under investigation, inquiry or trial, we have to suspend him.
Anyway, so probably you have no answer, therefore you are making such
Then
submission.
may I rely on one judgment?
Yes, you may. How can it be done?
This is reported in 2003, Volume 6, Supreme Court Cases, page 516.
Just give us a minute, please.
I would like to place paragraph 14 onwards.
How this is relevant? This has nothing to do with consequence of suspension. This judgment has nothing to do with consequence of suspension post its revocation. Nobody is questioning your discretion to suspend. Nobody has questioned the continuance. The issue is post revocation, what is to happen? So how this judgment will apply? This is,
Post revocation, he is entitled to full salary.
then why he has not got it?
No, he has got it.
The entire salary for the suspension period.
No, not for the suspension period,
So
post suspension.
so therefore,
post
how this is not relevant to that. This has nothing to do with that.
This job, why I am relying this is because it says that suspension does not automatically deemed to be inoperative when it is revoked.
You are not arguing, you are saying something which is totally out of place. This is not an argument. You are enlightening us by telling us that these are provisions, but that has no relevance in your case. Your case is suspended on 9/9/13. Your case is revoked on 22/2/19. After that, you say we will not pay him for the period he was suspended. Only subsistence allowance.
Because he
How
has
can
not
you
been
justify?
because he has not been acquitted.
So therefore, you are penalizing him.
Yes.
So under which provision? That is what we are asking you. From where you get the authority to do so? If you are permitted to do so, then without conducting any proceeding, it will be possible for an employer to place someone under suspension, continue him as such for 6 years like you have done, and revoke it. So he is deprived of salary for 3 years anyway, whether any proceeding conducted or not proceeding. No proceeding. Wonderful.
No, but we cannot proceed because act
That
is a
hardly
bar.
matters. That hardly matters. That does how
My lord,
that will not
act is a
that
bar
will
upon
not
us.
that will not sustain the deprivation.
My lord, when the
Whether
act,
you have the power to deprive him, that is the only issue.
kindly see Rule 42 and
Not
Section
required,
80.
sir. Not required, sir.
Section 80 and Rule 42.
Yes.
Rule 42.
That's not an issue. You are arguing things which don't
Because
arise.
we cannot. What has fallen from your
We are
lordship
not
is
going
that.
to enter into academic discussion of these rules.
My lord, what I am trying to impress upon your lordship is that
That you cannot conduct a proceeding. So
Yes.
therefore, you will deprive him or penalize him by withdrawing half his salary, like that only.
because a trial is pending.
Wonderful submission
Because a trial
by a
is
government of India employer.
because a
That
trial
we know we cannot proceed him against him, so we will deprive him or penalize him by depriving him of
proceeding,
his.
disciplinary proceeding and
Can record this
suspension.
submission.
Disciplinary proceeding and suspension are two different aspects of the act.
That's exactly what we are trying to say. That is exactly what we are trying to
Proceeding
say.
is for penalization and
Exactly.
And-
Suspension is not for penalizing.
not for penalization.
Correct.
But when a trial is pending against an employee,
Anyway, so that is your
an
submission.
employee, then
Anything else?
he has to be suspended. Rule 42 and Section 80, I was just intending to place.
Section 8042 doesn't matter, sir.
My lord,
You said yourself that the act is silent as to what is to be done after revocation. Once it is silent, it will be governed by the general law. Once a suspension is revoked, a person cannot continue to be deprived unless the revocation is on account of a conviction in a trial or the petitioner being held guilty in a departmental proceeding, and in the proceeding the disciplinary authority has dealt with how the period of suspension is to be treated by a decision with reasons for withholding that period.
My lord,
Not like this, that will not give you. Because we can't proceed against you, will not give you. Wonderful stand.
no, but when the trial is there, we have to suspend him, my lord. When the trial is going on, we have to
You
suspend.
don't have to. You have the discretion.
Clause 3 says that whenever trial is pending,
Please
For
read
us-
again. Please read again.
48 clause 3, my lord.
No, not 3, sir. You can't go direct to 3. Read it
Yes.
from the beginning.
Notwithstanding anything contained in.
First, read 40A1. What is the word use?
My lord, I am coming. The appointing authority may at its discretion place a person serving under him under suspension, one where a disciplinary action under the act against him is
You missed
contemplated.
again. You please read again. Notwithstanding anything contained in this rule.
Notwithstanding anything contained in these rules, the appointing authority may at its discretion.
At its discretion.
Discretion, yes.
It's not a mandate. It's
Yes.
precisely what we are trying to say. You could have taken work from him when you knew that you couldn't proceed against him. So, did you want to penalize him by placing him under suspension? That is what we are asking. That I'll not pay you after we revoke the suspension. Wonderful.
No,
No mandate. So now we hope you understand what we are trying to say.
the Honorable Single Judge has proceeded on the premise that since we have not initiated a disciplinary proceeding, so we have to pay the back wages.
All right. That we
Our
maybe-
submission is that we are incapacitated to proceed in a disciplinary proceeding because civilians are also involved in the offense.
That's all. Heard the learned
My lord, my lord, I beg pardon, your lordship. Mr. Parthog is appearing in this matter for the respondent applicant, your lordship. As if he is contesting Vidhan Sabha election in Raniganj constituency, your lordship.
He is contesting the election.
Yes, your lordship. Vidhan Sabha election, your lordship. Raniganj constituency. Kindly fix the matter on.
Assembly election. He is contesting the assembly election.
Therefore,
I am for the applicant. Your Lordship, kindly come to Kunj order, my lord. That is paper book, my lord, volume 3, page 215.
Yes.
The volume 3, my lord, page 215, my lord. That is the improving order which are not challenged, my lord. Your Lordship, kindly come to
Page, please.
page 215, 215, volume 3. That is an order, Appellate Authority Deputy Inspector of General Police Chief Security Commissioner Metro Railway, Kolkata, that is respondent report is under challenge in the writ petition. Initially, it was challenged, my lord, before the petitioner, my lord. So she kindly come to The fact, original fact is that, my lord, the writ petitioner, that is paragraph 3, my lord, the writ petitioner aggrieved the said order of the appellate authority has moved instant writ petition on the ground. Entirely, the appellate authority could not apply judicial fine.
Where is the appellate order?
Appellate order মানে কত পেজটা please? কত পেজটা বলো? Page 108, 116, my lord. That is, my lord.
116.
Yes, my lord. Volume 2, my lord. That is 116, my lord. P12, annexure in the bottom. my lord. Appellate order DIG cum SSC Metro Railway, Kolkata on the appeal. See, just Jitendra, that it
Yes, we are reading. Has he annexed his appeal? Has he annexed the appeal also? The appeal, where is the appeal filed by him?
Appeal.
Is the appeal on record? You have it. Let us see.
Instruction from my junior, my lord, that all the papers not annexed before the writ court, my lord.
Anyway,
Only they are filed here.
so what was decided by the Honorable Single Judge? What was held?
Yes, my lord. That is that. Regarding second marriage, my lord, they are not say the
The writ petition was filed only challenging the order passed by the appellate authority.
Yes.
So what the Honorable Single Judge did?
You should kindly come to, my lord, the order.
Where is the order?
215, that is volume 3, my lord. You should kindly come to the finding portion, that is page 222. 20. The Darnet trial judge relying some order. You kindly come to my page 220, paragraph 15. The scope of judicial review as regards the decision of the disciplinary authority has time and again discussed and held that apex court views such decision.
Where is the prayer in the writ petition?
Yes, ma'am.
What was the prayer in the writ petition?
We are in the writ petition, my lord, only
Only appellate authorities or
page 8, my lord.
8,
Volume 3, page 8.
volume 3, page 8.
Volume 2, my lord, page 8. Volume 1, my lord, sorry. Volume 1, page 8. That is a prayer, my lord. '37, my lord. The prayer is that, my lord, a writ in the nature of page 37, my lord, volume 1. A writ in the nature of mandamus commanding the respondent, each of them, recall, resign, withdraw, set aside, purported order, that is order 17/8/2022, passed by the appellate authority in connection with the major penalty charge sheet.
Oh, so disciplinary authorities order was also challenged.
But
Yes.
Arya.
Yes, so what is the,
Your Lordship, kindly see that Allahabad High Court regarding this imposition of appeal and other things, Your Lordship, kindly come to volume 2, the page 148, That is the Allahabad High Court, observation, Page 148, volume 2.
where is, no, no, where is the order of the inquiry of? Where is the order of the inquiry officer? Where is the inquiry report?
The order dated, Millard, 6th February 2026, your Lordship's order, Millard. Millard, that is yet to be complied with.
What was the order?
The order, Millard, that
Yes, that is
the affidavit in opposition, which is a part of record, Millard, that was not there.
that has
We allow the learned advocate for the appellants to leave file in opposition, since we do not fight the affidavit in opposition was filed as per the submission of the learned counsel for the appellants.
It was actually listed 2nd of March, but that is not.
The affidavit, the paper book also, Millard, is incomplete.
My junior, forgotten this to carry the.
That is not the issue. The issue is you should have told us.
That is what I was asking. I was telling him.
You are proceeding as if everything is on order. You know it is not in order. That is not a good thing.
After arguing
তোকে তো আমি
this,
বারবার
he
বলছি তুই
revived
না।
Malad.
তোকে তো আমি বারবার বলছি, বলে দে জজ সাহেব। You should have told this.
File it. To be away for a couple of weeks.
There was certain pages which are not legible in the paper book. Can I take back the paper book and put in those papers? There are only 10 pages.
Yes.
Much
Please,
I will
whatever you do, make the
I
corresponding
will have it.
correction. They have allowed you to. Just paste the legible pages.
Millard, only indulgence, Millard, since I am out of employment, and Millard, can it be, it is possible, I do not know, your lordships are facing insurmountable load, Millard. If it is possible, Millard, any date, Millard. If they don't file
Yes, we will give you a date.
date. Huh?
No case is undated in my court. Every case has to be dated.
It was my fault, I was persuaded by her.
Who?
Election is there.
So what? What do you want?
We have no problem.
Sir, what do you want? What are you saying?
I am just telling that 23rd is the election day.
23rd is an election date. Here.
Yeah.
So what is wrong on 24th? Huh? Oh yes, yesterday did Mr. Mukherjee contact you?
Yes. The judgment.
See, after delivering we forget. So we asked him to ask you.
Yes. She, in the afternoon, Millard, he told me.
If you
I
can
will
just
send
ask
for
someone to give the case number only.
Case number. Yes. Yeah.
Perhaps the pro forma application is.
নাম্বারটা দিয়ে দিন।
Item 7. Within 2 weeks, you have to serve. Ah.
My lord,
8, my lord, I am for the appellant, my lord.
I'm for the respondent. My lord, Mr. Achinkur Mujana, he's not well. Praying not today.
My lord, on last day, my lord, matter was also adjourned. My lord, there is an section 5 application is there, my lord.
Can?
My lord, can 1 of 2025, my lord. There was a delay stated, my lord, 163 days, but that should be, my lord, 164 days. Because, my lord, the February month in 29th day, but that was calculated as 28 days, my lord.
How many days delay?
164 days. According to us, my lord.
93 days. as per report. Only 93 days.
Yes, my lord, that the application, my lord, when was filed for certified copy, probably that date was not calculated in my section 5 application, my lord. Yes, for this reason,
Time was not set off. So 93 days, what is the explanation? You want time?
Not done.
You will allow the delay application and fix it. Okay.
Watching Kumar Majumdar, he instruct me he not will kindly bring not.
Didn't instruct us to do that. He may have instructed you. We are asking you why he is not here. Where is he calling?
Not come to court.
Who is on record?
He did not fit, my lord. That's why he did not attend the court today. That's why he's taking time.
Somewhere. Not today.
my lord, already that adjournment will be recorded.
Yes, as great by number that.
My lord, I am appearing on behalf of the state, my lord.
Yes,
Over telephonic discussion, I came to know it was 30 lakh rupees.
30.
30, 30. And already that tender is expired, my lord. Tenure is over. A new tender we have already advertised, my lord.
Learned.
Ten.
Yes.
There is a delay of 77 days.
Application is served.
That is what I don't find the proof of service, but the other side had mentioned the matter. It's come up on the behest of the other side, but
The respondents have mentioned.
yes, it actually, Lordship, the court has interfered in the punishment that was given. Part of the punishment has been allowed and another part has been set aside. So it was
Appeal from both sides.
no, not from both sides, only from, ideally it should be because on the factual aspect, it has been held that the misconduct was there. So that way, but it's only in the question of punishment did the court
Quantum
intervene.
of punishment.
Quantum, not even the quantum was even allowed. But just there was this period of suspension not to be treated as on no work. Those are the small issues that were intervened. But they have not preferred any appeal against the judgment, but they have mentioned the matter for this.
That's why I never entertained mentioning from the respondent.
I really don't
Must have- Maybe we didn't notice that it was.
a delay of 77 days in filing this appeal.
You filed an application.
Yes, I filed an application because that is the defect. The defect is the delay can one take it. Can wait. Lordship, it will be can 1. Section 5 should be can 1. It was filed earlier. Problem is, Lordship, the received copies of the service have not been returned to us because we had issued the letter, but yeah, we have to-
Some notice.
And some notice again.
Item 11.
Lordship, in item 11, Mr. Bhudev Chatterjee is appearing for the respondents have been asked to pray for not today.
Not today.
Item 12.
Appearing for the respondents.
Lordship, I am beg to appear for the respondents applicant, Lordship. My senior is not present in the court today, Lordship. Please kindly note to the Lordship.
You are also not present in court.
Yes, Lordship, because my health condition is not good, Lordship. That's why I'm not present in the court today.
No, therefore we are saying he could have also appeared virtually. What is the issue?
Yes, state consists, it is an appeal, my lord, preferred by the state respondent, state government. My lord, they have concluded their submissions. I understand, my lord. Now, my lord, it is our turn, my lord. We are the writ petitioners.
Yes.
We succeeded in the writ petition, my lord. Now, my lord, in this case,
You are for the appellant.
state, yes, they are the
Somebody is appearing online also.
my lord, she is also, my lord, representing her senior, my lord.
So you are here for the state.
Yes, my lord, for the recapitulation, that the Food and Supply Department, my lord, by reason of a notification dated 8th October 2021, my lord, invited applications, my lord, for the appointment of the contractual employees, my lord, commonly and popularly known as, my lord, data entry operators, my lord. And it was stipulated, my lord, in that notification that they, in pursuance of, my lord, a notification dated 22nd July 2013, my lord, they, my lord, invited applications from the aspirants. Be that as it may, my lord, we all, my lord, responded to such application in terms of the notification dated 8th October 2021, which categorically and in no uncertain terms, my lord, states that such appointments tenure, my lord, is for a particular period. Be that as it may, my lord, after this appointment was made, my lord, suddenly, my lord, we came across a notification, my lord, on June 2022, subject to correction, my lord, that our appointment, my lord, stood cancelled, and as a result whereof, my lord, they further invited, my lord, applications from the aspirants as against the said post, my lord, and their terms and condition also, my lord, almost similar to those of, my lord, 8-10-80-21. My lord, our contention was their contention that we knew, keeping our eyes open, my lord, we entered the circuit, my lord, and we knew, my lord, that our tenure is for a particular period. And such replacement, my lord, was made according to the perception of the government, my lord, that this was made because there was certain necessities, and, my lord, also an enhancement of the qualifications, or there were certain modifications, my lord, that were made. Be that as it may, my lord, we also relied on a notification dated 16th October 2020, which categorically states, my lord, that contractual employment till the age of 60 years, my lord, and, my lord, certain benefits after the retirement that were conferred upon us by virtue of the notification. My lord, the Honorable Single Judge, while dealing with all the issues,
The notification of 2020.
16th October 2020 is a notification, 8th October 2021 is a notification, 22nd July 2013 is a notification, 8-10-2021 is a notification.
Said you have been disengaged from 22.
Yes.
13 to 22.
Yes.
13 to 22.
13 is a notification. No, I was not engaged from the date of 2013. I was engaged 8th October 2021 notification based on. Right.
21 to 22.
8th October 2021 is the notification invited applications from the aspirants as against the post, namely, my lord, data entry operators. We responded. Our appointment was for a period of 6 months, contractual.
So you worked only for 6 months.
Yes. 2022, my lord, they replaced us by saying, my lord, they said that we inviting a further application against the same post, my lord, with certain modifications.
All of you, 6 months.
Yes.
How many of you?
497.
Yes.
Now, my lord, this notification, my lord, this notification, my lord, so, my lord, this notification 2022, which ultimate, my lord, leads to the path of termination, my lord, that came to
Can you
me
please give us the two dates? 21 notification is of
8th October. Right?
no, your engagement. Your
Yes.
8th October.
In pursuance of this notification, we were engaged. Selection process comments. কোথায় গেল কোথায়?
Very few
Yes,
months.
8th October 2021, the food and supplied, that is Millard page 112 and 13. 130, na?
130.
130. Kindly, Millard.
That is 24/6/22.
No, 130, 8th October 2021 notification.
130.
130, 130. তাই না? হ্যাঁ?
128.
First, Millard, kindly turns Millard page 128. Then comes to Millard 130. I should have said Millard 128 first.
128 of what?
After 810, 128. I will take first Millard kind attention to 130.
128 of what?
128 of your lordship's brief. Stay application.
Yeah.
This is subsequent to 810-2021.
The total number of applicant is, my lord, combining both the appeal, my lord, it's 597.
Not 497, 597. Right?
We are taking up which case? How many cases are there?
Two cases.
We are taking up 13 or 12?
13, my lord.
116. 116.
এখন FMA 1758.
তাই না?
FMA
1758. FMA 175.
758. Yes, we have it. Which page you are?
But I am referring 8-10-2021, page 130. Huh?
26.
ছাড় 218. My lords got it. So this is, Millard, the starting point of our journey or entry, Millard, whatever may be. Millard, it categorically states, Millard,
And anywhere the individual dates of individual engagement of the four persons.
sorry, Millard.
Is the date of individual engagement of the four persons available anywhere? On which dates they were engaged?
Date of engagement.
This was the enabling order leading to their engagement. This is the enabling order.
Yes.
So when
This
they-
is the, Millard, this is, Millard, virtually
This is the-
enabling order. I am deeply obliged. In addition to this, Millard, this is the basis of our appointment. Selection process initiated on this basis.
No, the basis is anyway, it is at page 229, but this is pursuant to 229. So where is the engagement order?
133, possibly. Engagement order. 130, sorry, Millard, in my page, 135. onwards.
So dates are 18/1/22.
My lord, got it?
Yes, 18.
So, my lord, your lordships are referring to, my lord, 229.
Yes.
Let us see, my lord. 229. Yes. I'm extremely grateful, Millard. That was, Millard, my reference point, because I said, Millard, at the outset, Millard, that 8/10/2021 finds its strength, Millard, from this. May I read, Millard?
Yes.
One.
We have gone through it.
Your Lordship, no,
The
no,
government has taken a decision. The intermediaries are perhaps not letting the benefit of the salary go down to the persons who are working. Therefore, rather than going through an intermediary, we will directly engage professionals for such work of limited duration to complete a job. Pursuant to that decision, the departments were enabled to do this. They have issued the order in this Department of Food and Supplies. Pursuant thereto, you have been engaged in January 22 and disengaged in which month of 22?
Disengage, Millard, the memo.
30th April 2023.
What is the date?
30th April 2023.
04 2023.
So for 3 months you were there. About
6 months.
no, January 22.
1st November 2022 to 30th April 2023.
No, sir, you just showed the engagement order at page 136.
Yes, Millard.
136 is January 22. So it is a question of 3-4 months.
No. In pursuance of the Joint Secretary to the Government of West Bengal 136, in connection with 6 additional data entry 6 months, as per the selection list. And your lordships are referring to, Millard? One?
No, he has just shown the engagement order 136.
Or discontinuation.
No, 136. Please see what is 136.
In pursuance of order dated such and such, Joint Secretary to the Government of West Bengal, this office such and such, in connection with engagement additional data entry on purely the contractual basis for 6 months.
No, this is one of the petitioners.
Yes. Mandakini query.
So therefore, we are saying from January to April. Engagement in January and disengagement in April.
This is dated, Millard, 7/1/2022. Your lordship is right. And then, Millard, the order of disengagement
of
202, Millard.
Of 30th April.
202, Millard, kindly.
30th April. So 44 months.
Kindly sees.
Page?
Second, page 202.
Yes. So therefore, an engagement of 4 months. Existence of 4 months.
It says, Millard, kindly let us read, Millard. In pursuance of GO number such and such, dated 8/10/21, issued by the Joint Secretary, Department of Food Supplies, dated 11/10/21, and this office notification dated such and such, Sri such and such has been engaged at an additional DO on hired basis for ensure prompt and time-bound service related to work duration, ration card life cycle such and such, regular months 1/11/2021, and has been completed 6 months on 30th April 2022, which my learned friend said.
No, see what they are saying is, as per the order of this 8/10/21, we engaged persons for 6 months period. In that process, he was engaged in January. The 6 months having lapsed in May.
So duration is 6 months.
Duration of the government order 8/10/21 is 6 months,
correct,
but their engagement has come in between for 4 months. There may be some who were engaged in November, some who may have been engaged in December, some in March.
Different dates, Millard.
But the whole period authorizing such engagement is for a 6 months by 8/10/21. They engaged on different dates, maybe serving for different number of days or months, we don't know. But maximum 6 months.
Maximum.
There may be someone who has
Right.
put in 6 months.
So, Millard, our contention, Millard, first of all, the 22nd July 2013 memo, Millard, which your lordships just now referred to, Millard. This was issued by the Millard Finance Department. There was a specific submission, possibly, if my memory does not betray me, Millard, that Millard, the 22nd July 2013 notification, Millard, the one of the pillars of the argument that, my lord, there was no necessary approval from the, my lord, appropriate authority while engaging this, because the government has faced certain difficulties. Number one.
What is the relief granted by the single judge?
Yes, my lord, I need to place the order, my lord, because it cannot be placed in a fragmented manner. 307. Second volume. এইটা না ইনকমপ্লিট আছে অর্ডারটা। 307. Memo from the memo, my lord, your lordships, my lord. 307. 307. May I? 307 কোথায় গেল রে? May I read for my lords?
So therefore, unless we have there is something more you want to say. 8-10-21, relying upon this, the other earlier decision of the Finance Department, the Food and Civil Supplies Department decided that to complete this ration card issue, we will have to engage some persons for 6 months. The writ petitioners were engaged in this process on different dates. On completion of 6-month period, they have been disengaged. The Honorable Single Judge has said that how can they be disengaged when they have been, they should have been given permanence by virtue of the policy decision of October 2020. So therefore, this is the issue.
No, my lord, there are certain points subject to correction, my lord. What I have formulated according to the best of my ability, my lord. First of all, my lord, the series of memos issued by the government starting its journey from 2011, 2016, 2019, these were not placed before the Honorable Single Judge. And 16th October 2020 memo, which, my lord, my learned esteemed friend, my lord, while, my lord, making this argument, the relevance of 16-10-2020, my lord, that it says, my lord, that this is inapplicable in the present facts scenario. He argued, possibly, my lord, that our engagement was for a specific period. Our requirement that was no more necessary, extending, my lord, the further period, and the terms of the contract cannot be rewritten by the court. And thereafter, this engagement with certain modification that is well within the ambit of the government. But this was not placed before your lordship, the well-settled judicial principle, because after the judgment was passed, kindly look at the date of the judgment, that is 6/5/2025, when the court, my lord, heavily came down upon them, my lord, saying that this 16th October 2020 memo operates, my lord, the adjudicatory process. It says, my lord, the permanence has been given and there is nothing new to be added. It is not a case before the state government, before the learned single judge, that the recycling process in the ration card, my lord, it is a continuous process. This work is, my lord, perennial nature, and this contractual employment is sought to be replaced by another form of contractual employment, my lord, which is, my lord, impermissible in terms of, my lord, the Supreme Court judgment.
No, but that is not what the Honorable Single Judge held.
No.
The Honorable Single Judge held that by virtue of this 16-10-2020,
correct,
a sort of permanence or security of tenure was contemplated for persons like you.
Right.
You cannot be deprived of that.
Right.
That is the judgment.
Number two, my lord, since it's a division bench, my lord, and it's a continuation of the appeal, and the principle of civil procedure code, my lord, applies to the writ proceedings, and section 107 of the Code of Civil Procedure, my lord, your lordship knows, my lord, that, my lord, it says it is a continuation of the proceeding.
Yes.
And my lord, it's a point of law.
Correct.
First of all, my lord, the nature of employment, the attendant circumstances, court is evaluating the conduct of the parties in the proceeding. The government, while issuing the memo, for instance, my lord, whether I am correct in saying, my lord, when the parliament or the legislature frames a law, it presupposes or presumption of law is this, my lord, parliament or legislature is aware of its earlier legislation. While government, my lord, enacted not, issued this notification dated 8th October 2021. It
16th October.
8th October 2021, by under which, my lord,
under which you were
appointed, the government was quite conscious about, my lord, the existence of the memo dated 22nd July 2013 and the previous memos, which my lord gave permanence to all employees, all contractual employees. The sentence, the word used consciously by all. So, my lord, the honorable single judge, possibly subject to correction, was correct and justified. The honorable single judge, my lord, I would submit with humility, my lord, correctly interpreted, my lord, the tenor and premise of the notification.
We have not gone to that. We are saying this is the case.
Yes, correct.
Yes, we
I
have
am
not gone on
responding.
whether it is correct or incorrect.
Correct. But I
We
said, my
say
lord,
that in view of the notification of 16/10/2020, you cannot be deprived of the
correct. My lord, I'm
object
extremely
of that
grateful.
notification.
That is exactly what, my lord,
And therefore, the honorable single judge said that you please take them back. They are deemed to be
Yes.
permanent in terms of this
Yes.
16/10/2020.
Now, my lord, where
So
the
therefore, what we are required to see is whether 16/10/2020 is applicable to you or not. They would be contending that it is not. They would be saying that it was. They have said that it is for a short duration. They have said that the new notification is for appointment, laying down different qualifications. Your engagement was with a specific term that it was temporary, and as within that temporary period you were disengaged. Therefore, you cannot claim a better right.
Yes. Now, my lord, what is the strength of such a submission, my lord? The government proceeded while the appeal was filed, my lord. The order under appeal, my lord, is dated 2nd May 2025. The 5th May 2025, 6th May 2025. Subsequently, page 322 of your lordship's brief, my lord, there was an attempt on the part of the government, my lord, which says that the notification dated 24/6/2022, which refers to disengagement of the writ petitioner, has been sought to be justified by saying they clarified, my lord, they interpreted, my lord, the order of the disengagement after the pronouncement of the judgment.
So
This
that is
point,
not relevant for us.
no, because this point, because I tell you, lordship, why the data preference of the appeal, my lord, kindly sees when this appeal was filed.
But that is an event subsequent to decision by the single judge.
But my lord, this
So
is
that was not part of the consideration.
correct. But if that is, because that is the whole strength of the argument. Government said, my lord, 322, my lord, kindly sees, it was, my lord, given to the Secretary Department of Personnel. It says seeking clarification regarding notification dated 16th October. Kindly, my lord, have a look to this, my lord. My lord, because this is an executive inroads into the judicial order, my lord. That is my humble understanding of the situation. Seeking clarification regarding notification dated 16th October 2020, issued by the Department of Personal and Administrative Reforms, e-governance, such and such the High Court judgment. This is impermissible.
This is an intra-departmental communication in the process of consideration whether to appeal, and if to appeal on what grounds. That does not create any right or does not take any away any right that is otherwise vested in you.
No,
This is between them. This is not. This is not issued to you. And what is
this
the worth of that? We'll see.
This was issued, not issued to me, but this is, my lord, this memo, my lord, ignited, my lord, this particular state the government, my lord, to prefer this appeal. Because 16,
it is in the process of
my
decision.
lord, kindly, what does it say, my lord?
And that is not impugned. We are not going to go into that.
No, correct. But this is a part of record, my lord. Court can
It
take
is.
note. Court can take
we
note.
can. We
Yes,
can.
court can take note of the subsequent.
We don't consider it relevant. We are at the very
yes,
outset. We are
no,
saying
because
that
it
is
says-
irrelevant.
Because it says, my lord, that why, my lord, government preferred this appeal. Government preferred this appeal.
Whatever they have decided, we are not going to look into that. We are only going to look into the judgment of the Honorable Single Judge, the facts which led to passing of the judgment,
Yes.
how they have deliberated and decided to file an appeal is
Now, my
not
lord,
relevant.
my lord, permit me, my lord, to the reasons that weighed with the Honorable Single Judge, my lord.
Let's come to the
judgment.
First of all, let's see 16/10/2020.
Yes, 2020, the memo. 226. Whereas the government of West Bengal has in last few years initiated a large number of e-governance reforms including computerization of different services to improve the case of doing business in the state, as well as to ensure seamless transfer of welfare benefits to people. In order to achieve this, different departments have engaged IT personnel, particularly data entry operators / computer operators. This engagement of IT personnel in different categories has been done either through WebL or WTL, similar agencies, even while some engagements have been made directly departmentally. And whereas the terms and conditions of service of this contractually engaged personnel in this regard vary widely across various departments and among different categories. And whereas a number of benefits like security of tenure, leave terminal benefits, etc., which have been allowed to other contractual employees at large, has often not been extended to this IT personnel, leading to suboptimal utilization of their services. Now, therefore, in view of the critical role played by this contractually engaged IT personnel, kindly see the word, I'm putting emphasis on this, in the continuing success of e-governance reforms, their service conditions have been reviewed. It has been felt that the present terms and conditions of their engagement need to be improved upon to retain the best talent in the state government and get best services out of them. With this end view, the state government has decided to make the following changes in the terms and conditions of the engagement of IT personnel engaged under regular establishment and in different programs project, whether state engaged through WBM departmentally or through other agencies. Direct engagement under government. Contractual IT personnel working in regular establishment under the state government and or under any project but engaged through WTL, WBBL and any other similar agency will come under the direct control of government as contractual workers. Benefits to be extended. I am also putting emphasis on this, Miller. Security of tenure. The contractually engaged IT personnel shall be given security of engagement up to age of 60 years. They shall not be terminated except on the ground prescribed in such and such 16/9/2011. Miller, that is the memo I referred at the outset, Miller. Leave, 30 days leave in a calendar year, 10 days leave on a medical ground, maternity leave, such and such. Then nodal department, PA and art department, PAR will be nodal department in respect of such IT personnel. This order will take effect from 1/11/2020. This is issued in concurrence with the finance department VD such and such dated 16 October. My lords got it? Yes. So we are in the regular establishment. Now, my lord, while interpreting this, when this, my lord, was relied upon, and 24/6/2022, my lord, kindly comes once again. 24/16, which Miller talks about our disengagement. 24/6, sir. পাতাগুলো মিলছে না, 201 বলছে আর 218 কি করে আসছে? 201 and 218. I'm sorry, Miller, for being late. 201 and 218 both make me. 201, Miller, kindly first.
We don't take exception to the delay. We take exception to the way you are. You don't want me to understand anything.
201 is the memo which Miller takes away our right 218. 201.
When you are conversing about proceeding, at least I should be able to understand what you are saying, teacher.
No, he is saying that before I placed 218, Miller, he was asking me to place 201.
I know. Unless
Sorry, Miller.
Unless
Miller,
I can-
no, Miller, I'm sorry, Miller. It was, I'm sorry, Miller. I should not have, Miller.
Yes.
Miller, 201,
Yes.
in pursuance of the memo dated 8/10/21 issued by the Joint Secretary, Department of Food Supplies, read with memo dated 11/10/21 and this office notification dated 11/20/21, Suman Singh has been engaged as additional DO on hired basis for ensure prompt and time-bound service-related work, Duare ration card life cycle management and paddy procurement and other regular works for 6 months with effect from 1/11/2021 and has been completed 6 months. Now, as per direction of the Secretary to the Government of West Bengal Department of Food Supplies, engagement Suman Singham such as discontinued with effect from 1/5/2022 after completion of 6 months satisfactory service and Millard also the nature of work Millard the ration card duare ration card life cycle management and paddy procurement and other regular establishment work for 5 months. Then Millard kindly comes to 218. This is Millard, this memo, which was Millard the subject matter of challenge before the Honorable Single Judge. Placing the services of data entry operators in various offices under Food and Supplies Department on temporary basis. Food and Supplies Department, West Bengal, requires a service of Millard 342 data entry operators in various offices under Food and Supplies Departments on temporary basis. Out of these 244, DOs are required to be engaged in the field offices of the under Directorate of DDPS, while the rest 98 shall be assigned for various offices under Directorate of Rationing on temporary basis for 1 year or till requirement is over, whichever is earlier. These DOs will assist the office staff and or perform duties in the office for data entry, scanning documents, processing the initial works related with ration card and other online service in the portal. Same work. The field offices are located in various blocks, municipality, subdivision and district headquarters where these DOs will be required to provide services. Now, he is requested to select and provide the required numbers of DO in the district offices as mentioned in the enclosed list. Now, the conditions, Millard, eligibility, these conditions are there. Candidate should be graduate in any discipline like that.
You applied.
Then Millard?
You applied.
No, I did not. I said Millard because I questioned Millard the propriety. I said, and Millard, this is also for a period of 1 year.
There is a hiatus between your disengagement and this notification.
Millard, this is Millard.
This is of June, late June. More than a month after you were disengaged.
Yes. This was done.
So
and
for 1 month you did nothing. Only when this came out, you came to the court.
Because
and you did not apply also.
Millard, no, I did not apply. I questioned Millard the propriety of
No,
this.
you did not question the propriety. You did not question the advertisement on any other ground than that no appointment can be made.
Because Millard, one of the pillars of my submission that I was contemplating that government might recruit Millard on a permanent basis. It is not a case because law of this land, Millard, till date, subject to what my lords will say, that a contractual employees cannot be substituted or replaced by a contractual appointment. That is the standing, Millard, the order, Millard, of the Supreme Court.
All right.
If that is so, Millard, there was no contemplation. I could not apprehend the government would, Millard, engage the similar nature of the employees.
So what you brought you before the court is the purported replacement of one set of contractual employees by another. The court went on the issue that in view of the decision of the government to give some kind of security of tenure, the moment you are engaged as a DEO, that extended to you.
Because, Millard, the 16th October 2020 memo, it does not, Millard, make any difference or it does not speak about any intelligible differentia with the object.
Therefore, if this is upheld, then henceforward any DEO once engaged, he cannot be disengaged.
Millard,
the moment he is engaged, he is extended
Millard, there is a ground
benefit of 16/10/2020, and then
Millard,
he will remain till
Millard,
the age of superannuation.
They can do it subject to, Millard, the compliance of paragraph 9 of the memo dated, Millard, November 2011.
Yes.
It categorically states.
Yes.
Because it says why the government, Millard, conceive a situation, Millard, the government on the one hand will not, Millard, recruit direct employees despite there being vacancy. On the other, the government will engage, Millard, at a very lower, Millard, wages, Millard, to Millard, appoint, Millard, contractual employees in the establishment. And, Millard, the government...
How is that relevant? How that is relevant?
Because, Millard, the government said, because government has engaged us.
This entire decision is because of introduction of so many e-governance platforms and e-governance initiatives. It has nothing to do with the general recruitment being done earlier. It is for a specified purpose. Time to
Yes.
time data entry operators are required.
I am
Therefore,
extremely
they engage through WTL or Webel, whatever it is. They say the intermediaries are siphoning away most of this amount that we spend. Rather than going for that, you may engage directly, but do it for a very specified period to to complete the work. Now you say the moment they resort to that, 16-10-2020 comes into play, and there is no scope now for.
let us see, Milord, that what is the judgment, what is the reasoning?
That is what we have seen. The judgment
Milord,
says
16th October 2020.
2020. That is the sheet anchor on which
Milord,
the judgment is
correct.
founded.
Milord, 16th October 2020. Milord, and not only that, Milord, there are certain memos. I said government has taken a very consistent stance which does not create any cloud or confusion, Milord, in the mind of anyone, subject to correction. To 11/2021, government has come up with a notification. All contractual employees, kindly, Milord, have the charity to consider the word all contractual employees. They will, Milord, secure the tenure of their service, Milord, till 60 years. Possibly, my Lord, your Lordship, while sitting with Justice
21. The 21 circular.
Not 21 circular, 11, because it refers to, Milord.
No, 11 is not for these DEOs.
No, this is
the
for all
16-10-2020 is specifically deals with DEOs. And that is the benefit extended to you by the Honorable Single Judge.
Now, Milord, 16th October 2020, which your Lordship says, Milord.
No, which the Honorable Single Judge says.
Honorable Single Judge says, Milord, whether this benefit should be conferred upon us, Milord, relentlessly.
No, what we are trying to visualize a situation that the way the prayer has been considered, that means the moment a DEO is engaged, he becomes a permanent till the age of superannuation.
No. Milord, so long as it continues, the purpose is alive. Here, Milord, the question your Lordship will not be pleased to find any sentence from the affidavit. Kindly, Milord, have the charity to consider, Milord, what was the stand taken by the government. Whether government.
We are asking you. See,
no, I can say
we are
that if
asking
the law
you,
is otherwise, if the law confers a benefit upon the employee, first of all, Milord, whether your Lordships approve the view that state is a model employer, it's a welfare state, and, Milord, the guarantee of an employment
that does not require any approval today.
No.
From anyone that does not require any approval today.
I said
that is a settled law.
Settled law. If that
The
is
point
a settled
is,
law, then what is the consequence, Milord?
within that concept, there is a free play in the joints. There are so many opportunities to the government to find ways and means to deal with its requirements. One of the very well established, recognized modes of achieving this requirement is through contractual engagement, duly recognized by series of judgments. So this is a contractual engagement. 16-10-2020, if applied in the way it has been done, there leaves no scope for anyone to be engaged even for one day.
Milord, kindly, Milord.
The moment he is engaged, he becomes.
Milord, if
he will be there till he attains the age of superannuation.
There is a fundamental difference between a master-servant relationship in a private firm and the government.
That's not an issue. That's not an issue arising here.
Today,
issue is 16.
No, question is, Milord, if the language is not clear, if the language, Milord,
16-10-2020 is the only issue, sir. There is no other issue.
16-10-2020, Milord, no words possibly could be added in the notification.
Exactly. That is what we are. We very much agree with your view. Not a single word can be added. Neither it can be enlarged, nor it can be squeezed.
Correct. 16-10-2020.
Yes.
In no uncertain terms, this memo is in vogue.
Correct.
It has not been modified, not cancelled. If that is in existence, then, Milord, your Lordship's view, once you are engaged, you cannot be thrown out. Possibly,
no, not in my view. Not in our view.
Correct.
That
it says, Milord, it can be done. Let us see, Milord, once again. 226. I read for my lords, Milord. I'm extremely grateful for giving us enough indulgence, Milord.
Just read the first three lines.
Yes. 226. And I will also, Milord, show your Lordship how this has been interpreted and how the Supreme Court has said so. And I will also show, Milord, the continuous issuance of memo, Milord. The government, Milord, has not made any departure while issuing 1610. Whereas the government, the first lines, first paragraph, the government of West Bengal has in last few years,
Yes.
yes,
Now proceed.
large number of e-governance reforms, including computerization of department services to improve the ease of doing business in the state, as well as to ensure seamless transfer of welfare benefits to people. In order to achieve this, different departments have engaged IT personnel, particularly data entry operators, computer operators. This engagement, IT personnel in different categories has been done either through such and such or WTL or similar agencies, even while some engagements have been made directly departmentally, or whereas the terms and conditions of these contractually engaged personnel in this regard vary widely across various different departments and among different agencies. I am skipping over, my lord. Kindly comes to, my lord, the benefits under this memo. It cannot be.
Benefits are not in doubt. For whom?
For whom? For
That is
us,
the
my
issue.
lord. No, my lord.
That is the issue. Not
Yes.
the benefits, but for whom?
Whereas, my lord, whereas a large number of benefits like security of tenure.
No, that is not an issue.
Yes.
That's not
Now,
an
my
issue.
lord, this memo.
For whom?
For whom, my lord? They said it talks about. my lord,
Forget about what they say. What does the
my lord, I said, my lord, this is not only confined to the persons who have engaged before 8/10/2021.
but it will apply to anyone
No,
engaged.
I said, my lord, because this memo, otherwise, my lord, the government has put emphasis on the perennial nature of work. Because the government, my lord, has taken a consistent stand because 8/10.
They have understood what you are saying.
Yes. Because I tell your lordship, contractual IT worker under any but engaged to any
How
other.
much more time you will take? How much more time you will take?
But I will show certain judgment, my lord.
We can't continue now. And second half, I have a bench with His Lordship Justice.
Tuesday possible.
Justice Bhattacharya. Tuesday, I don't know. Let us see.
Wednesday,
Is
Lord
Tuesday,
Justice,
Tuesday free hai second half.
Friday.
Huh?
Next Friday is possible.
But
Next Friday.
we
Next
can have
Friday.
it. We can
Next
have it
Friday
that day.
possible.
2 p.m. is free.
Next Friday.
Are you free on Wednesday?
Wednesday, my lord, another bench has.
So you are not free for us.
One matrimonial appeal is continued. Because that's all.
27. We can complete on
Yes,
27, hopefully.
Yes. I have to cross.
Judgments that you propose to rely upon. Can you give us a list of the citations or something?
Give me, my lord, half an hour time. I will try.
Please do so. Please do so.
First,
We will not come with a preconceived notion, but we'll at least know what you are going to do.
whether it applies to us.
We'll just go through it.
Yes.
beforehand.
I make a list and hand it over to. আপনাকে দিয়ে দিচ্ছি ওটা.
Yes, with the 2 p.m.
Extremely grateful.
Yes, grateful. Number 107, you have got that judgment. Mr. Tapan Mukherjee, you have got the judgment. Give it to him, give it to him, give it to him. Just read the last few paragraphs. The petitioner cannot be denied the benefit of the certificate dated 6/9/14 and denial by the authority to issue an appointment letter based on the order dated 4/3/24, purportedly based on a medical examination dated 15/1/24 under the above noted provisions of WBSR Part 1 is unsustainable. The order dated 4/3/24 is in as much as it deprives the petitioner benefit of the statutory certificate of disability dated 6/9/14 is unsustainable. The order of the Special Secretary Ayush Health and Family Welfare Department, Government of West Bengal, dated 4/3/24 is hereby quashed. We therefore direct the authorities should proceed to offer the appointment letter to the petitioner without raising any objection as regards the certificate of disability dated 6/9/14. The order of the tribunal dated 15/5/25 passed in OA number 423 of 24. In our opinion and in view of the above conclusion is unsustainable. It is set aside. The writ petition is allowed in the above terms. The OA stands accordingly allowed. We direct the authorities to proceed with in compliance with this order expeditiously and process the petitioner's claim after assessment and verification of other relevant parameters contemplated in the recruitment process, if any, positively within 8 weeks from the date of receipt or production of a copy of this order.
Before
Not there. On the next day it will come. When the bench assembles, it will.
Your Lordship, I'm mentioning for review case number 350 of 2025. The order was passed on 26th September 2025. Same division, Honorable Bench. So my case is not appearing despite mentioning twice. And I am facing severe financial distress for the last 49 months. I have no pay, no nothing. Thank you.
Matter number one.
ওইটা আর কত বলা নাই তো
Instruction কি?
The Lordship on the earlier occasion directed the state respondent to file a The Lordship on the earlier occasion directed the state respondent to file a report as per the
No,
further
we didn't.
allegation.
We asked them to take instructions.
I've not been able to.
Huh?
I've not been able to get instructions.
Mr. Mukherjee, this is contempt matter. These are contempt matters.
The allegation is serious in nature.
Yes,
Not a single penny has been received.
Today,
Already you have communicated the decision that they have decided not to assail the order. If they have not, they have decided not to assail the order, then why they are not complying? You see the order of 13/6/20
there is a compliance order. Report has been filed. Affidavit has been filed.
filed.
Yes, compliance report. Can you see? Affirmed on 27th August 2025.
No, but they have. But she said that she has not received any salary. Therefore, we asked you. What is going on? That is, we don't know. See, you come to paragraph 7 of your compliance report.
Yes.
Nowhere you have said that it has been paid. You say we have done this, we have issued letter to him and this officer and that officer, but there is no averment that it has been paid. And he was making submission on specific instruction that it has not been paid.
Yes, ma'am.
And if the situation is the same till date.
Next week, any day can be returned at any time. It will not more than 10-15 minutes. Number 20.
Presently, my lord, petitioner is suffering from starvation, my lord, due to such lawful conduct by the state.
Universal.
নয় এটা বারবার করে অর্ডারটা দেখতে পাচ্ছেন এটা কি আছে
The matter is being fixed on 27th of March.
Make sure the payment is done. Don't.
কোনো কাজ করে না
Number 2.
Your Lordship, I appear for the alleged contemner subject to what my learned friend submits, Your Lordship. Applicant number 1, who is the main applicant seeking for the pensionary benefit, is deceased as on date, Your Lordship. And the order passed by Your Lordships has been assailed before the Supreme Court and it is pending consideration. Your Lordship, there was a direction passed in the interregnum to release the pensionary benefit. The authorities have computed the pensionary benefits, and when the amount was due to be released, Your Lordship, it was informed that the petitioner has expired, Your Lordship. So we have taken steps before the Supreme Court, so the orders may be modified accordingly. Because the other petitioners, applicants who are the family members, Your Lordship, then the family pension, applicability of family pension comes into play, Your Lordship. So accordingly, the steps are being taken before the Supreme Court to modify. Yes, Your Lordship. Your Lordship, the order has been passed. The notice was directed to be served. Yes, Your Lordship. Minimum pension. Yes, Your Lordship. Lordship, thereafter, the family pension issue will come into. Yes, sir. Yes,
Your Lordship's order already in similar type of matter in Aproja, Your Lordship recorded, Mr. Mukherjee was there. They are trying to settle the issue other day. This is a similar
That
to,
is a separate
but
petitioner altogether.
he is not properly instructed. In respect of the pensioner, it was substituted before the tribunal. Petitioner before Your Lordship is a widow. Now what I do not know what type of instruction.
Sure, he is the
This is the family pension.
Family pension. Yes, Your Lordship.
Then widow
So
dies.
The widow dies. It has to be substituted accordingly, Your Lordship.
All other legal heirs. I do not know why you are making this type of submission, because all the legal heirs in the petition there.
Show documents, Your Lordship. The
Sir, kindly take the
computation has
first
been
item.
completed. Your Lordship,
Later
computation has been come.
I do not know what type of
Your Lordship,
CPC whether says so.
The legal heir, being the petitioner applicant number 1, she is also expired, Your Lordship, as on date. So they have to also take steps, Your Lordship, accordingly.
My Lord, kindly now, my Lord, kindly take page 8 of the contempt petition. But I am so surprised to if the other legal heirs are.
We are only pondering over whether, when a contempt for the compliance of the same order is pending before the apex court, whether we should take up the issue. That is primarily what is crossing our mind.
There was a direction from the Supreme Court. Kindly take the Supreme Court decision.
Yes. No, but you have preferred a contempt before the apex court.
No, we have not.
No.
They're
Prior to
proceeding
that.
with the contempt here. The
Just now you said that.
I have not said.
Oh.
we
They
have
are
proceeded
saying,
before.
Where is the order? Let us see.
yes, kindly take your lordship's order, judgment as per 141. And what type of limited interim order was there before the Honorable Supreme Court?
Yes. Yes.
All right. So, therefore, by which date you will make the payment? Tell us.
I oblige. Submit this, Your Lordship. The
Who is he?
the original.
Who is he?
He's my instructor.
He is the competent authority.
He's
How much time? Ask him to come.
Your Lord-
Executive of the family pension is for the only wife.
Wife.
Our unmarried daughter. Now her daughter is married, and we cannot give the family.
And the
pension
wife
to
has
her
expired.
children. Now, unless Supreme Court has also given, Honorable Supreme Court has also given interim order that the family pension to be given. So right now we cannot do anything. Accordingly, State Council has been informed that what direction comes, if required, then the family members, legal heirs will get the benefit only. They will not get the pension. Whatever pensionary benefit coming from the date of retirement till date, that benefit till the expiry of the deceased or till date, that benefit will be passed on to the family legal heirs. Sir, after getting the direction, what to do, how much, because it was interim order. So family pension is like monthly pension, sir, which can be only given to the wife or unmarried daughter. In this case, this is not applicable.
None of them are applicable.
This is the main problem. Three,
Your Lordship.
Three.
Proshit Noshkar, Pradeep Noshkar, and Polshiri Noshkar Bera. The married daughter, 2 sons. Yes, Your Lordship. And the wife, who was the applicant number 1, eligible?
No, I am telling, they are mixing it up. From the taking consideration of 10 years minimum. That is now as on today. Calculating 10 years to the legal years. Why? I'm giving the explanation. They are the sons and daughters. All three. Because they are the party before the Honorable High Court. Why? From the date of retirement of original employee, to some extent,
So, I'm extremely sorry.
rule says so. Government notifications are there. Married daughter is entitled if she is dependent on the family member. To that extent. I am not on that. Yes, 3 persons, 3 sons and daughter will be entitled. I am not on family pension of the daughters because this is not a lease before your lordship. I cannot expand this in this petition. It is to be paid from which date to whom, and they are the legal heirs who will be the beneficiary of that amount. Will be there. Correct. Yes, they are entitled to receive it. See, according to the share. Oh, according to the share, 1/3 of the family pension as well as family pension. As I am trying to. Oh, if your lordship, yes, my lord, I am told if my lord directs to make payment of the first son, it will be served. It cannot be. Yes. Otherwise, 3 equal. It otherwise, my suggestion would be, it should be paid in equal share 3. My lord.
Whether she is dependent, she is not dependent, all these things they will have
My
to
lord,
see.
subject to correction, my lord, one thing, in your lordship's time. In the original proceedings, 3 sons and daughters as well as the widow was claiming to the extent of share of the employee from the date of entitlement till the date of death, up to 2020. Thereafter, Geeta Noskar family pension up to that stage. Now, Geeta Noskar died during the pendency of the appeal itself.
Geeta Naskar was the applicant.
Applicant.
Perhaps not. Her
Yes.
husband was perhaps the applicant.
Husband died. After the death, she made an application for getting, after substitution, a paid for.
She was the original applicant before the tribunal.
For getting the portion of the pension of the deceased husband as well as the family pension on her behalf.
So therefore, she has, the others have joined her, but if she were alive today, the payment would have been made to her.
Yes, would have been. Possible. Let us file an application for affidavit disclosing if the payment as per order of the Honorable Interim Order of the Supreme Court, they can make calculation and pay payment to the applicant number 2 in lieu of, on behalf of 3 and.
No, they will just make payment relying on whatever you say, that you pay to ABC, whoever it is.
Yes.
And then it is for you to decide what you do with that.
Let us think about our entitlement. Let them. But within 3 days, I shall file affidavit.
The
Record my submission. Make payment to one of the applicants. Yes, I am obliged to you because it is to be the only solution.
Let's see.
Let us see. Let us see.
Let us see how, what sense prevails among.
Obliged to your lordship. User মধ্যে করবি, copy দিবি। Can you record this? I shall file an affidavit to that extent. Can you record that? Wish to file an affidavit to that extent.
For the petitioner. I am for the petitioner.
Or I am interfering. Can it be instead of 27th any other date? Let it be. Because on that day I shall not be there. I shall not come. Affirm.
Hmm.
20. Get.
Okay, good.
I just now.
As senior division electrical engineer. In the district authority. No, my name I have sir. Yes, yes. Let's come to page 3. Page 3. Yes. They don't give, my lord. That is the problem. Postal department does not give. Postal department.
Item 4.
What am I saying?
Item 5. Item 6.
What me?
Yes, sir. Well, it is against the principal accountant general. Lordship. As per your lordship's direction, this is coming for the first time. Lordship may kindly see your lordship's order. On the basis of our concession, which is evident from our affidavit, lordship's order is at page 68, recording our concession. Your lordship, in the penultimate paragraph, has been pleased to direct regarding the stand of the respondent as stated in their supplementary affidavit today. We direct that the entire process of grant of first is the inter se seniority with effect from petitioner's initial appointment and consequential benefits be completed by the respondents within 6 months from date. Over here, the petitioner contends that thereafter, as per your lordship's direction, we have complied with your lordship's order, that is at page 81, whereby the notional promotion, page 81, kindly read along with page 73 of your lordship's brief. Yes, page 81. Yes, 25 August. Your lordship will kindly see that the principal accountant general so-and-so is to issue the order of notional promotion in respect of so-and-so with effect from the date mentioned against their name. The petitioners' names are all appearing in serial number 36, 39, 40, 50, 51, 53, 64, and 76. All are there. Now, over here, there are principal grievances is because since the order which we are to comply is not in personam, but in respect of the entire cadre of the post by which, your lordship has seen that so much of compliances have to be undertaken. Yes, Now, they are now saying that kindly come to your lordship's brief at page 26. The nature of the violations which they are now alleging. Serial number, they are now saying, they are interpreting your lordship's order to contend that actual promotions have to be given in serial number 1. Kindly come to page 26, the violation, the nature of the violations which they are alleging. They are now saying that by not giving actual promotions, thereafter consequential benefits, which we are saying is in process because it is in REM. It involves various other departmental officers whose every pay, their seniority have to be adjusted. 3 is back wages. It is not reflected in the order. Now this MACP, it will take time, All India combined eligibility list, all will take time because it has to be done from the head office from Delhi. And they have been accommodated in their respective post, and the increment, whatever is there, I have instruction that they are getting from the date when they have been absorbed. As per the notional promotion has been given, what your lordship inter-se seniority, the salary has been refixed. Now, whatever is the effect will be reflected in their pensionary benefits with regard to the past services. Lordship. My lord, DPC, my lord. My lord, it is in process. Whatever is the All India combined eligibility list is centrally prepared. My lord, the office of the principal office from Delhi is looking into this matter. My lord, over here with regard to the MSCP, the seniority has been fixed notionally. My lord, the increments are all given. My lord, I shall take instruction. Without proper instruction, my lord, I should not be say. Lordship. 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 My lord, our instruction, if I may put. No. My lord, I am not now saying it is all in the process with regard to the futuristic benefits. Yes, my lord, futuristic benefits, whatever is accrued, we are not going to deprive anybody. My lord, all that. I'm sorry, my lord.
It will become futuristic after they are at the position which they deserve to be as on date.
Yes, my lord.
Then only the issue will
The
be.
prestigious, all the requirements which are required as per the revised
Seniority.
all will be given in due course.
No, but 6 months we had given you.
Yes, my lord. Whatever is there, my lord, we are trying to.
So you must specify some time.
Yes, my lord. Give us some time to file our affidavit.
How much time?
My lord, give us 4 weeks time to file our affidavit. In the meantime, my lord, Lordship's query is.
Let's see what they come with. The
Yes, 24.
it's hardly a question of 1 week thereafter. Please try to do it.
Yes, ma'am. And 7.
7 and 8 are same, my lord. Same as 3, 4, 5.
My lord, that is not.
No, 3, 4, 5.
3, 4, 5. The earlier matter.
Oh, in this case, oh, this is like 345, same order as 345.
345 notice to be issued.
Oh, this is the first day, okay, for serving notice.
Seven H.
Tonight. For review, I'm saying leave to withdraw this review.
As prayed by London.
Item 11.
The affidavit of service, but it's all come back again. I can give the return. But the addressee is left without instruction, and then again, oh, it's sent back to the GPO. We can't trace him. It's
Then how to do it? Resub. This is the incorrect address.
this was the address that is in our records, everything, even we check the phone number.
What is the postal receipt? What is the endorsement?
Endorsement was addressee left without instructions. Then again, what is showing is deliberately returned to the GPO. It's
Obviously, it will
for
be
us.
returned. What can we do? You send it afresh. If the address is same, then you send it afresh.
Chip, that is wait, a phone number.
We don't know what left means. Left means changed
Yes,
address
I
or away
understand.
for some
Nothing.
time.
Oh, he did not come to collect the parcel. That also could be.
Or maybe he was not there when they went for delivery.
This is the address in our records also, Lordship.
He's your employee.
He's a superannuated. He's no longer retired. Then if he was our employee, it would have been an issue.
But there is no service, either in fact or in law.
Throughout. I mean, this was the address that we had sent the writ petition. Writ petition was accepted. This is the first address we had sent, which was returned. Thereafter, we got
Learned counsel, can an instruction be short for the concerned collector?
otherwise there's no other alternative because, I mean, the second address that we found, that also it's showing is left.
Oh, you have sent it on two different address. Oh, so that means he's.
On the previous occasion, it was the first round of service. No such person in this address was the endorsement. So it came back. Then now it's a second round.
So how did you get the second address?
From the records, from the records from Allahabad. So
Because he must be receiving pension.
he's receiving pension. Bank থেকে trace করে ওখান থেকেই connect করে। বলছে মোবাইল নাম্বার But people send it to his email. They say that there is an email. Then we send it to the email. Next. What is it? What is it? 20th. Huh? 24th April.
And 12. And 15.
Not today.
My lord,
Not today.
submission. My lord, review petition and contempt petition both will be heard together. Last time he has made this submission. Yes, my
Yes.
lord. My lord, my humble
Today I'm
submission,
handicapped
my lord.
and junior just now left because of
Petitioner is specially able person. My lord, he is retired. He is going through financial crisis, my lord. Last time also he made this submission, my lord. Review petition may be heard, my lord, and contempt petition. Next date, then it should be to be mentioned, my lord, because the petitioner is going through financial crisis, my lord. On next date, my humble submission, it should be to be mentioned. He is the senior, my lord. He can be. Litigant person is suffering, my lord. I understand. You are the supreme, my lord. Wait on. Next date to follow. Promotion, since the promotion and promotional benefit. Yes, my lord, he is retired, my lord. My lord, he is retired, my lord. Specially able person. He is not getting any, he is not in job, my lord. He is retired already. No, my lord. He is not getting pension. So that was the main order, that order was passed by this bench. Then contempt petition was filed. He is not getting any benefit. My lord, kindly, I will go through the order, my lord. Yes, my lord. May I read, my lord? 25, 26, 27, 27. The order portion, my lord. My lord, kindly go through the synopsis, my lord. May I? December 2025, he is retired, my lord. My lord. But he is because of this, my lord, case is pending because of that pension. is pending, my lord.
16. Item 17. Respondent plaintiff declared.
No. Appellant. No. Appellant. It's fixed for hearing appeal, na? Fixed for hearing appeal. This is in relation to.
Item 18.
Malad.
Reading me, my lord, he left the court, my lord.
Malad, may I intervene? May a date be kindly fixed?
18. 18.
Not 7.
27. 24th April.
24th April. Rest of it.
Item 19 and 20.
Not intervene. 76, sir.
19, I am appearing for the petitioner, but the respondent is not there.
But, and 20, I am appearing with the petitioner. Now, this matter was argued by Mr. Anindya Kumar Mitra, my lord, the checkered history, where the excise, the point is that, my lord, already, one matter assembly is already argued, but due to our application, if the lordship can give some precedent, whenever lordship sits, I am not on that. This can be. No.
It's already taken up.
We have argued complete argument, respondent, kindly see the order, bro.
No, we need not see the order. So we'll record your argument is complete.
We already recorded that Mr. The respondent were to start today.
So then let them start. On a prayer.